last event of the year will be our annual meeting at the Pacific Club. Our featured speaker will be the mayor. And the Pacific Club made a mistake. They overbooked the room. But I'm pleased to announce that we're going to be seated in their, what they call the mango area. And I'm told that to make it up for us, they're going to give us free champagne. So there's a deadline of December 4th where we need to give them the head count. So if you haven't sent your reservation in, send it in as soon as possible, because there's a limited amount of champagne that will be available. Okay, so I'd like to introduce Mark Murakami and Greg Kugle, who gave the litigation update last year, if you might recall. Mark is a director at Damon Key, Leon, Kupchak, and Hastert, and practices in the areas of condemnation, land use litigation, and probate and trust litigation. He was a valedictorian at the Richardson School of Law and was on the Law Review, and served 13 years in the United States Coast Guard and ships in as a JAG, and is continuing in the U.S. Coast Guard Reserve. Greg Kugle is also a director at the Damon Key Law Firm and practices in the areas of land use litigation, commercial litigation, and environmental law, and has litigated cases in the Hawaii Supreme Court, the Intermediate Court of Appeals, the District of Hawaii, and the Bankruptcy Court, and state courts throughout Hawaii. Greg is listed in Best Lawyers for construction law and land use and zoning, and also in real estate law, and was the 2013 Lawyer of the Year in land use and zoning law. So let's give a hand to Mark and Greg.
Thanks very much. We're really pleased to do our second annual real estate litigation update for this section. The group is getting smaller, and so I'm wondering whether or not there's really a market for what we're delivering here. But in any event, we kind of compiled a snapshot of the real estate cases that came out from both the ICA and Supreme Court this year. We don't talk about foreclosure law. There's a lot of statutes and a lot of cases in that area, and it's just too cumbersome. It's probably its own separate section meeting in and of itself. Some of the cases that we're going to talk about today, we were counsel on, and we limit our discussion of the facts to those facts that have been disclosed in the opinion, and we try to be as objective as we can be, especially on the cases that we lost. But Greg does a better job. I don't think he has any losses. I have a couple losses on here. So anyway, there's no real organization, and we've kind of split up the cases to talk about today and tracking last year's outline. And so without further ado, Greg, why don't you start off?
Yeah, and I will editorialize a little bit more, especially on the cases I didn't work on, because I have to make something up to make it interesting. But also, I think if the outline was emailed around, there are embedded links in the email to either the briefs or the opinions or whatever, so that you can go back and get those if you want. I'm going to start today, and we'll kind of follow the order of the outline, and there's two cases I'll start off with talking about before I pass it off to Mark, and those appear at the top, dealing with real estate contracts. And both these cases, Morioka versus Lee and Furuya versus AOAO Pacific Monarch, both of those are ICA opinions. Both of them are memorandum opinions. And my apologies to anybody that worked on them, but both of them are memorandum opinions for a reason. And so I read them, you don't have to, and they weren't that exciting. And so I'm not going to give a lot of time talking to them, because they're very fact specific, and I think that's the reason why the ICA didn't publish those. And there's not actually a lot to learn from them other than one or 2 points. Morioka v. Lee was a lawsuit between a parent and her adult child and husband, and it was over an alleged oral agreement to sell or give mom's interest in the home to the kids. And the debate or the issue in the trial was whether mom agreed to give 50% interest or 100% interest, and the deal, I think, was that the her daughter and the husband were going to move into the house, take care of dad. Mom was moving out of the house, I think, to get away from dad, and so they were going to assume some debts and take care of dad, and then, you know, and I think the lesson should be whenever you have a family fight like this and suing each other over an oral contract, it can't go well, and it didn't. What actually happened was the circuit court had granted summary judgment on the grounds that you think. Mom was sued by the daughter and the husband for specific performance, to enforce for breach of an oral contract and a number of counts. She moved for summary judgment on the grounds that you would expect when you have an oral contract for the sale of land, right? Well, remember statute of frauds and where's Professor Callie's real property? So that'd be a natural. The circuit court had granted summary judgment, and kind of the only lesson here is the ICA reversed it and said that there were issues of fact, and that's because there were disputed issues about whether there had been partial performance on this oral contract, which would remove it from the statute of frauds, and whether there was also adequate remedies and some other things. So the court, I think not surprisingly, reversed the circuit court and said you shouldn't have granted summary judgment on these issues. The lesson there, obviously, is I mean, if you have an oral contract for the sale of real estate, there's so many, there's so many exceptions to the statute of frauds that it's going to be difficult to get summary judgment, and that's what that case teaches. The second one, Faruya versus AOAO Pacific Monarch, the plaintiff in that case had the least fee interest in an apartment unit as well as a number of parking stalls. The AOAO had acquired the fee interest, and so it was, there were negotiations. The plaintiff wanted to buy the fee interest in his unit as well as the parking stalls. The association wanted to buy his interest in the parking stalls. And I saw that, oh, well, there's a DROA in this case, so that's been replaced now by a purchase contract, but it's like, okay, there's a contract here. But when you read the case, you find out that that it was, a DROA is a DROA for a reason, which includes the words offer and acceptance, and this one had been filled out by the would-be buyer and sent, but it had never been signed by the AOAO. So the ICA opinion affirmed a trial court finding that the DROA wasn't enforceable because the association hadn't signed it. And there was some evidence that the association manager had said verbally, yeah, sure, we got a deal, but they didn't sign that. And so, again, if there's any lesson to be gleaned from that one, it's if you have the contract, have both parties sign it, or it's more difficult to enforce again. So I think that was the ICA in those two cases, just kind of saying stuff that we probably all know already. With that, we'll move into the section in the outline that talks about land use and development litigation, and Mark and I will both do some talking.
Okay, so there's the first case we're going to talk about is the Kelberg case, and it's Kelberg 3, and it's tied very intimately to the Molfino case down at the bottom of the paragraph, so I'll discuss both. The reason why Kelberg is 3 is that there was an ICA decision in Kelberg versus Ewan. The Supreme Court took the case, reversed the ICA. On remand, the ICA issued another decision. The county appealed back to the Supreme Court. Oral argument was about 6 weeks ago, and so we expect the Kelberg 4 any time now. This is a really weird case because the procedural history is dramatically, if you read the case, it's all about Chapter 91 appeals and what decisions have to be appealed to the County Board of Appeals in Big Island. A landowner of a property about 50 acres north of Hilo asked the county, this is the Molfino case, asked the county how many lots can I subdivide my this 50-acre parcel into. It was Ag 20 zone, and the county said 2. And so they looked at the county said, we looked through our files, there's no exceptions, so you get 2 lots out of that. So Mr. Molfino sold to Mr. Kugle, who then applied for and got subdivision of 7 lots on that parcel. It's 6 lots on the 49 acres, and then there's another sliver kind of adjacent, but not quite next door. And this was former sugar plantation homes where the sugar plantation had 10 houses there, and a couple years back the County of Hawaii allowed those sugar plantation homes to be subdivided and recognized as pre-existing lots after Big Sugar shut down in Big Island, and there's going to be dramatic upheaval, and there's no way the new landowner is going to subdivide, and the infrastructure costs would be so huge. So the county allowed these pre-existing lots to be recognized and subdivided, and therefore mortgaged and alienated. So magically, they're in the DPP, or the planning files in the Big Island. There were a couple letters, 10-year-old letters from prior planning directors recognizing pre-existing lots up there that weren't in place or weren't discovered when Mr. Molfino asked for them. And so new buyer gets subdivision and starts selling the lots. There was what, I think 1 or 2 lots left, and so realtor who was selling them calls up Mr. Kelberg and says, you might want to buy one of these because you could consolidate it and you have a much better parcel. So Mr. Kelberg, kind of shocked that his neighbor subdivided land and he wasn't actually given notice. So wrote a couple letters to the county saying, what's going on? Why didn't I get notice of the subdivision as was required by the county code? County says, these are pre-existing determinations, and Mr. Kelberg kind of challenged them on that, and the county looked at it and said, oh, looks like we made a mistake, and we recognize too many lots, but we're not going to do anything about it at this time. So Mr. Kelberg ultimately brought a lawsuit in circuit court, original jurisdiction, challenging the county's approval of the subdivision. Various procedural motions, exhaustion, primary jurisdiction, and the like, and ultimately the circuit judge orders a remand to the Board of Appeals, which is our ZBA version for the Big Island, in order for them to hear the case. That the letter saying, oops, we made a mistake, was a decision of the planning director that needed to have been appealed to the Board of Appeals in the first instance before the circuit court could hear the case. So off they went to the Board of Appeals. The Board of Appeals looks at it and says, look, we have a 30-day statute of limitation to hear cases or appeals from people aggrieved by planning director decisions. We're years past that, therefore we have no jurisdiction, we're not going to hear the case. So the parties go back to circuit court, and ultimately the circuit judge says, look, you failed to exhaust. You needed to have appealed the decision of the director, the planning director, to the Board of Appeals. Because you didn't do that, you lose. The ICA agreed. Supreme Court looks at the case earlier this year and says, look, you have to, if the government is going to foist upon you very tight, narrow statute of limitations, you have to tell people that these statute of limitations are going to run. So I don't know if you've ever looked at the City and County of Honolulu's letters, when you have letters going back and forth about requesting declaratory rulings on your zoning or if you can build or whatnot. There's a block on the bottom that says, this is a final decision of the director. If you want to appeal, see this county code section and you got to go to the ZBA. No such block was on the letter that he received from the planning director. And so the Supreme Court said he wasn't required to exhaust. The court did have original jurisdiction and ordered the lower court to hear the issue and whether or not this subdivision was illegal. The ICA, because it got to the ICA on motions for summary judgment, the parties had agreed that there were no issues of material fact, and so the trial court ruled as a matter of law. The ICA said there are no facts in dispute, so we can issue a decision, and they voided the subdivision with the ICA. So the county goes back to the Supreme Court and says, these lots have been sold to people. They weren't joining this party. There's some problems with just undoing a subdivision. So the Supreme Court's hearing the case. Well, the decision should be out probably in the next 6 months. I expect there's probably some remand that's going to take place. Interesting. So Mr. Molfino, who sold his 50-acre lot thinking he could only subdivide it twice, and then a year later the guy's able to do it to 7 times, brought a lawsuit against the county of Hawaii saying, I asked you, and you had these missing letters, and I was entitled to rely upon you telling me there were, I could only subdivide into 2 lots. And therefore, you committed negligence, and it's actionable, and I should be able to recover for that. That went to the Supreme Court, and I think it was last week. Yeah, last week, the Supreme Court said that the county did not have a duty to maintain its records properly and to advise Mr. Molfino about the issue. And there's, I'm sure, a lot of backstory about where those missing letters, the pre-existing lot determinations, were hiding. But I don't know that Mr. Molfino is going to get any recompense for that. So that's Kalberg and Molfino. Stay tuned. I think that the next batch, or the Supreme Court's decision will talk a lot about what the remedies are when you have governmental errors and the subdivision that shouldn't have been approved, and can you undo a subdivision? So it should be an interesting one to watch. Kauai Springs versus County of Kauai was a very personal case that I'm going to be very objective about it because I litigated it for 10 years. Kauai Springs is a small water bottling company that started a business on ag land in Kaloa. It tapped into a pipe which had been placed into Mount Kahili, a couple miles away from the Kaloa site, over 100 years ago. It was used to, there was a small farm subdivision, Makai, of where Kauai Springs was located, and it fed the little farms and diversified ag type deal down below. Kauai Springs put up a couple Connex boxes with a roof and a reverse osmosis purifying machine, and tapped into some of the water that was coming down that pipe. So the pipe went to 20 farms below, and if the farms weren't using the water, it just spilled out of this little distribution facility onto the ground into a gulch down below, where it eventually perhaps could get to the ocean. So Kauai Springs tapped into that water to take some of this excess water and ran it through an RO and started selling it in the 5-gallon jugs all throughout Kauai. A complaint came into the county challenging the industrial use of ag land. So Kauai Springs applied for after-the-fact zoning permits in order to conduct this activity on ag land. There was a use permit, a Class 4 zoning permit, and a special permit because water bottling is not one of the enumerated uses that you're allowed to do on ag land. A rather fierce contested battle then took place at the Kauai Planning Commission. There's YouTube videos about it. The Kauai Springs, who it's like I think 5,000 gallons a day. There was significant amounts more water coming out of the pipe, but there was the activists. They were stealing the water. They were commercializing the water. A lot of racial overtones cast at Kauai Springs. Ultimately, so the Planning Commission says, well, we think that this violates the water code and you're a public utility, therefore we're going to deny it. One of the issues was they didn't deny it. They didn't deny all the permits in the time period set forth in the Kauai Planning Commission's time limits. So under Hawaii Revised Statute 9113.5, the permitting authorities had to adopt timeframes on which they would approve or deny a permit application, or if that timeline passes, the permit application is deemed approved. Not a lot of cases on this. There's a couple now that are kind of floating around. So a couple of the permits had the time period had lapsed. The special permit was the last one, and the Planning Commission knew that that deadline was hitting, and so they denied and said, we're denying you because we think you there's water code issues and we think you're a public utility. Despite the fact that Kauai Springs went to the Water Commission and went to the Public Utility Commission, asked them, and they got letters back. So the Water Commission said, Kauai is not a water management area. We don't regulate Kauai. There's a lot of water, so we have no authority to regulate that. The Public Utility Commission said, we don't regulate any water bottlers statewide. A public utility is like a monopoly. There's only one gas line coming from the street to my house. There's only one electric line, therefore you're a public utility. In this case, you can get water from a host of sources. And so the Public Utility Commission said, we don't think you're a public utility. Nevertheless, the Planning Commission said no. We came in and appealed the Planning Commission's decision to the Circuit Court under Chapter 91, and Judge Watanabe ordered that the permit should issue, that they blew the deadlines, and that the reasons they used to deny the permits, the Public Utility Commission and the Water Commission, were arbitrary and capricious. The county appealed to the ICA, and last summer the ICA came out with kind of a mixed decision. They said that the Planning Commission's decision to deny on those two bases was arbitrary and capricious. Plainly, it wasn't a public utility, and the Water Commission said, we don't regulate Kauai. Nevertheless, the ICA remanded for and set forth a test on what the public trust impacts were with regard to this proposal or this use pumping, grabbing the water that was flowing out of this pipe and selling it. We appealed to the Supreme Court, and in a 108-page decision, the Supreme Court found that the Judge Watanabe was incorrect, and that the public trust doctrine trumped this process. And they set forth on there's a handful of public trust cases in Hawaii, and it's puzzling as practitioners. Every water case in Hawaii seems to be 100+ pages, and it's a very difficult doctrine to really kind of wrap your hands around, and it tends to look a lot like it's kind of outcome determinative. Nevertheless, the Supreme Court did set out, and I'll go over the list for you. On page 85 to 87 of Justice Pollack's opinion, some principles that agencies who, in the course of approving permits and reviewing permit applications, and all agencies from the Kelly decision from the Big Island have a public trust duty, but they can't. The Kelly case stood for the proposition that you can't just look at the four corners of what you do. In that case, it was a grading permit application, and a community group challenged the potential water impact from doing this grading and it's spilling into the ocean, which is a public trust resource. And the Supreme Court in that case said, sure, you can't just look at the permit application and turn the blinders on to potential impacts of what they're doing. Anyway, I don't want to read it because it's like there's 10 factors, and footnote 25 says that this is a framework for assistance and do not indicate that it is mandatory or that it precludes other analytical approaches that are consistent with the public trust doctrine. So for folks involved with the development of water resources in the state of Hawaii, you gotta look at Kauai Springs. Very challenging to know what the case is actually gonna mean in practice. We haven't seen yet how the planning commissions and the different authorities are gonna handle that. So the Kauai Springs wasn't asking the Kauai Planning Commission for permission to pump the water. Parties all agreed the source was a grandfathered source because it had been going on for 100+ years. The pipe was an existing system that everybody agreed that required no additional permits or approvals. So the application was just whether this use of land was like the enumerated uses in ag type things. And so our point was that, look, if you take a picture of it, it looks like a farm accessory farmhouse type deal. There's trucks going to and fro, just like every other farm. And so the inquiry should be based on the use. We're not asking for permission. They weren't asking for permission to pump the water. Nevertheless, Supreme Court did what it did, and so that case got remanded to the Kauai Planning Commission, where everyone's trying to figure out what to do next. Very interesting case to follow. Water law, I don't think was helped with this decision because it really kind of confuses things. Speaking about water, you want to do?
I don't want to speak about water,
Okay.
but I will speak.
I'll
speak about land first.
Okay.
And kind of the way I organized the few cases I'm going to talk about, I mean, they're agency specific. I'll talk about Land Use Commission, then I'll talk about Land Board. I mean, clearly though, and for some of the points that we'll talk about in the cases, the application goes beyond that. I mean, it's a lot of administrative law, agency law stuff, and it applies as equally to, county planning commissions as it does to these state agencies. But these were the contexts that they came up in. So one that is not on the list that we handed out, but it's, as I look back at what we covered last year, it had come out from the Supreme Court after our presentation last November, which is the Sierra Club versus Castle and Cook case. And so it's not linked in the material. The citation is 132 Hawaii 184. Came out like right at Christmas time last year. And I want to talk about that because it also sets the stage for a few more cases that I want to talk about that should be decided very soon. So in Sierra Club versus Castle and Cook, that's the Waiaba Ridge development, Coal Ridge it's called, which is actually had been to the Supreme Court before. I think back in '03 when the project was challenged. They had to get Land Use Commission reclassification approval to take the land from about 767 acres from ag to urban to build about a 5,000 unit residential mixed-use project. The first time it went to the Supreme Court, they hadn't done an EIS at that stage, at the Land Use Commission stage, and I think it was the Sierra Club was the plaintiff in that one too, back in the early 2000s. Appealed, and the Hawaii Supreme Court said, "Oh, you need to do your EIS at your earliest possible stage." They had said, "Well, we'll wait till we go get the county zoning after." So the court said no, sent it back down. Then you get this case now, which is 2013. That one involved, they did their EIS, went back to the Land Use Commission and applied for the reclassification again, and I think their application went in 2007. And the interesting thing is, I have to talk about one of the Land Use Commissioners. Commissioner Kanuha had been appointed by Governor Lingle in 2005. His term was up in 2009. So as the Castle and Cook project's going through the contested case hearing process, Commissioner Kanuha's term expires. He's re-nominated by the governor for a second term, and the Senate rejects his nomination. A few months after that, he's continuing to sit on the commission as basically as a holdover commissioner because the seat hasn't been filled. So it comes down to the vote day on this reclassification petition, and to reclassify land, you need 6 votes out of 9 at the Land Use Commission. There were only 6 people voting that day, and Commissioner Kanuha was one of the 6 that voted in favor of reclassification for Castle and Cook's project. Sierra Club challenged that and said that he was not a proper holdover commissioner. They shouldn't have counted his vote. Circuit Court agreed with that, Judge Sakamoto. That was appealed to the ICA. The ICA reversed and said he was a proper holdover. And I'll tell you what happens at the end of the day, but I can't make sense of when. I mean, it's really kind of contorted as to who's appropriate or not. The point is, if somebody isn't re-up, you ought to look at this if it's your thing that's being decided. Anyway, so the ICA said he was okay to vote, and it passed. And then it gets up to the Supreme Court, and in 2013 they come out and say, no, Sierra Club was right. Professor Callies, who likes to point out that Sierra Club's often right. I'm going to prove Sierra Club wrong, though, and we'll talk about that later. But the court agreed that he could not vote, should not have voted, and therefore the reclassification petition 4 years later, now 2013, and it had gone into court in 2010, was out. So you think that was the end of the story, but it's not, because Castle and Cook is nothing if not persistent, and also smart. So in the meantime, while that was all up on appeal, they came back to the Land Use Commission again with a reclassification petition for the same land and the same project, and that one was going on with hearings at the Land Use Commission in 2011 and 2012. And so in 2012, the Land Use Commission voted to approve the reclassification again. And so I guess by my count, that's the third time over a decade that the Land Use Commission had done that for that project. And in the middle of it working its way through the Land Use Commission and then into the circuit courts on an administrative appeal, that's when the Supreme Court decision came out. So the Supreme Court decision is probably of no effect, really, because they're already moving forward one more time with the reclassification. I had some fun kicking around with some of their attorneys what might happen if the Supreme Court had affirmed the ICA, because then it's already been reclassified and you've got the same petition coming through, but that didn't happen. But that brings me maybe to the next case or cases that I want to talk about, which is both the Coal Ridge case as well as one that was going through at the same time that I'm working on, which is the D.R. Horton's whole Peely case. And that also involved ag land out at Eva that needed to go through the Land Use Commission reclassification process. And it was going through, actually they started before this most recent effort by Castle and Cook on Coal Ridge. In both of those cases, as they were proceeding through contested case process over a year or two at the Land Use Commission, there were interveners in the cases. Interveners included the Sierra Club and included Clayton He, and the arguments they were making was the Land Use Commission shouldn't reclassify ag land. We need, we need farms, we need food security, sustainability, all those kind of, buzzwords. The commission went ahead and voted on both of those different projects, voted to reclassify. And I should say, Sierra Club and Clayton Key were intervened in both cases, and they were making the same arguments. So they took appeals to the circuit court of both cases that were not quite occurring at the same time, but within a few months of each other. And the circuit court happened to be the same judge, because she gets assigned administrative appeals here in this circuit, decided both cases, decided the Land Use Commission was correct. It had sufficient evidence in front of it to justify the reclassification. You have to go meet a whole bunch of statutory requirements on reclassification, and they had some detailed findings of fact and conclusions to law. So she affirmed those two. Both cases, the attorneys for Sierra Club and Clayton Key took an appeal to the ICA, then they moved to transfer to the Supreme Court. And so the cases are now fully briefed before the Supreme Court. They actually moved to consolidate the two cases, which the Supreme Court declined to do. I think everything now was briefed as of earlier this year, and so we're waiting to see if the Supreme Court will set it for hearing or just decided on the briefs. We don't know yet, but we expect that to come out. And the real issue, this is the important part, or the interesting part, is not so much did the Land Use Commission did it have enough evidence in front of it, and that kind of thing. What the attack that they're really taking is saying that Article 11, Section 3 of the Hawaii Constitution says basically the state shall protect agricultural land. I'm paraphrasing, and to reclassify it, whether it's a city council or the land use commission or the legislature, whoever's doing it has to have a supermajority, 2/3 vote. If any of you remember the Save Sunset Beach case from about a decade ago, somebody brought a similar constitutional challenge to a rezoning up there on the North Shore, and that had not passed the city council with a 2/3 vote, and they said, well, you violated the state constitution that says you have to protect important ag land and you have to pass with a supermajority. The Hawaii Supreme Court said in that case that constitutional provision was not self-executing. In other words, it's not like the Native Hawaiian rights provision that you had in PASH or other things. Rather, the specific language that they put in 1978 into the Constitution said the legislature shall pass a law to protect important agricultural lands, and put it within the legislature. And the legislature at the time of the Sunset Beach case hadn't done that yet. Well, fast forward another few years, and looking back in the last 8 or 9 years, I guess, for any people that were involved in the whole important agricultural land or IAL process, that's now been put in place following the Sunset Beach case, and each county is going through its own process to determine what are important agricultural lands, and this is under Act 183, which was an amendment to Chapter 205. The net result is going to be that counties and landowners are going to identify important ag lands. Those lands will come through a process before the Land Use Commission and not be set aside in perpetuity, but the landowners get some benefits for doing that. It's more difficult to take that land out of agricultural use in the future. And the idea is to preserve that important agricultural land. Well, that's the key to these cases that are now on appeal. The argument being in both the Coal Ridge case and the Ho'opili case that the Land Use Commission, while the counties are undergoing their process, and the City and County of Honolulu is still in the middle of that process, the Land Use Commission should not have reclassified any ag land out of ag and into urban under the theory that, well, maybe someday, hypothetically, that land could be designated important ag land, but if you reclassify it now, it never will be. And it's a nice argument. It doesn't work because the IAL Act actually excludes land that was always been planned by the counties for the state for urban development, even if it's in ag now. And that is the case with the Ho'opili land. I don't know if that's the same thing with Coal Ridge. So in other words, it was never eligible for IAL designation anyway because it's been on Honolulu's general plan and development plans for the second city of Kapolei, basically. So the Hawaii Supreme Court has said, yeah, we think that's important enough to take. I don't know how to read that, but it's been briefed, and it won't be decided before the end of the year, I don't think, because they will have already said by now whether they're going to have oral arguments, which they haven't. So that's out there. And I think it poses an interesting issue, which I think this year may not win. But that brings me to another case on the list, which is a spin-off of all that called Friends of Makakilo versus D.R. Horton, which was the same reclassification case, another intervener called Friends of Makakilo. And this is probably more of a Civ Pro administrative appeal lesson than anything else, but it is a reported Hawaii Supreme Court case that came out last month. The other parties that I described earlier in the case took their administrative appeal, Chapter 91 appeal, from the Land Use Commission's finding of fact conclusions of law, and Chapter 91, 9114 and Rule 72 of the Civil Procedure Rule says you have 30 days to file your appeal. What this intervener did was they didn't file within 30 days. They waited till other people filed their appeal, namely the Sierra Club and Clayton He, and then they, in reliance on Rule of Appellate Procedure 4, which provides for cross appeals and says you get 2 weeks to file a cross appeal from an appeal in the appellate courts, because it's an appellate rule of procedure, they said we have the right to file a cross appeal. We can do so outside of the 30 days. We can do so 6 weeks later. The circuit court dismissed that as being untimely. They took an appeal. They asked the Supreme Court to consider it, so that one bypassed the ICA as well. And the Supreme Court said just last month that the 30 days means 30 days, and that the rules of appellate procedure don't give you more time at a circuit court on an administrative appeal. You can denominate your appeal whatever you want, from the agency to the circuit court. You can call it a cross appeal if somebody else has it. Doesn't matter, but you have 30 days, and the statutes and rules are clear about that. And probably the practice lesson is, and there are a lot of Hawaii Supreme Court cases on these, you can make a lot of mistakes on an administrative appeal. You cannot include all the right parties. You cannot serve people or name the state agency. You do or don't have to include a statement of the case. There's not much you have to do, except it says that jurisdictionally, that 30 days, you have to get that notice of appeal in 30 days. So that's probably a practice pointer as much as anything. But that was the one opinion that's actually come out on those cases in that Land Use Commission stuff. Let me say, this is fun. So I think it's not so much what happened in 2014, but what's teed up to happen fairly sooner in 2015 before the Supreme Court. And this is another one with the Land Use Commission, and it's the Ainalea cases, if you're familiar with that. Land that was in Waikoloa, about 1,000 acres, was reclassified 20 years ago from ag to urban for a residential development, including, at the time, I think they said 1,600 affordable homes were to be put out there, affordable housing under the, I guess it was the county definition. Over the years, the project wasn't developed, but the property owner, as it changed hands, came back to Land Use Commission a few times and said, well, we can't do 1,000 units, we can do 500. Well, we can't do 500, we can do 300. So that kind of brings it up into the mid-2000s, when they came before the Land Use Commission and got that number reduced to about 300 homes. But the Land Use Commission put a timing element on it and said, okay, you need to have certificate of occupancy by date certain. And it was a very complicated process to the Land Use Commission, but the long and short of it was they did not accomplish all of those homes with certificates of occupancy by the date required. And if you can read anything into it, probably the Land Use Commission got very frustrated, I guess. And so they used the procedure that's in the statute and the rules called an order to show cause. They issued this order to show cause and said, come before us, property owner, and explain why we shouldn't revert this back to ag or to some other classification. They went through some hearings and a lot of briefings, and they ended up issuing this order reclassifying the land from ag from urban back to ag. And that was really, I believe that was the first time that they've actually done that. There have been attempts to get them to do that before, but that was the first one. And so, not surprisingly, the landowner fought back pretty hard in several respects. They filed an administrative appeal to the Third Circuit, Judge Strantz, and said, that's not fair, we're being singled out. The other interesting argument they made is that for the Land Use Commission to revert land back to what it was, you have to go through basically a reverse boundary reclassification. You have to make all the same findings, follow the same procedures to put it back from urban to ag as you went through to move it from ag to urban. The state, for its part, well, so this has now been briefed at the Hawaii Supreme Court, and I think they had oral arguments either earlier this summer or last summer, I'm not sure, but it's been a while, so we expect a decision to come out. And that's really the key issue that the court is being asked to decide. In other words, can the Land Use Commission revert land when somebody doesn't comply with conditions? And if so, does it have to follow this more rigorous process, or can it issue an order to show cause, have a hearing, and decide to revert it? Relatedly, the property owner filed a state court civil lawsuit claiming violation of due process and equal protection and other things. That was removed by the state, so they sued those land use commissioners who voted to reclass or voted to revert. The state removed it to federal court to Judge Mulway. She said, I'm going to stay this while your administrative appeal is going forward because that may resolve things. That was appealed to the Ninth Circuit. The Ninth Circuit held oral arguments out here with the property owners arguing that the district court shouldn't have stayed the case. They should have kicked it back to the state court, which would have put them in the same state court as the judge who, in her administrative appeal, found violation of constitutional rights as part of her Chapter 91 review. So they wanted to get back there, obviously, to pursue a takings claim and a constitutional claim. The state argued to the Ninth Circuit that the district court should have dismissed the suit against the commissioners in their individual capacities because they were immune, and she shouldn't have stayed the case and not decided that. Everybody argued it. 2 days after the argument here in Honolulu, the Ninth Circuit, so it was submitted for decision, right? Nothing else to occur other than for them to release an opinion. They issued a one-sentence order saying it was unsubmitted for decision and that the parties are supposed to advise them when the Hawaii Supreme Court decides whatever it decides. So, I mean, they did, I guess it's like cert improvidently granted kind of a thing. So anyway, that's going to present something very interesting because the question is, the Land Use Commission finally tried to put some teeth into what it does and got, slapped back by the circuit court judge on the Big Island, and by the property owners. And so this will be a real test for the Supreme Court to say, what can they do when it comes to enforcing conditions that they put into reclassifications? I think I want to mention one more case, which is a land board case, Pila'a 402, and I'll be real brief on these. Pila'a 400 versus the land board, BLNR. That's a case that comes out of Kauai. It was property that was owned by Mr. Pfluger, and it involved a mudslide or fall after some unpermitted grading work that went into a bay. So this was not the dam breach that happened elsewhere over there, but this was one where unpermitted work was done to cut a road and a cliff above the ocean, which was technically in the conservation district. And then what happened was you had heavy rainfall and a lot of mud ran off across the beach into the bay, which was, according to the experts, a pristine bay. So the land board issued a notice of violation for the conservation district rules. They held it was assigned to a hearings officer. The hearings officer imposed a $2 million fine based on a lot of expert testimony about damage to the reef and this type of thing. That comes back to the land board. The land board doubles the fine, says no, it should be $4 million. And then that was appealed. And so what the Supreme Court was deciding in that one, there were a couple interesting arguments. The ones I think that are really relevant were a jurisdictional argument, and it was all this unpermitted grading work occurred outside of the conservation district, so the Department of Land and Natural Resources doesn't have any jurisdiction to issue violations for work that occurred outside. The Supreme Court dealt with that by saying, well, technically a sliver of this land was in conservation, including where you did some cutting and road building, so that without having permits from the land board for that, that's a violation, as well as all the regulations prohibit the placing of soil and material and other things in the conservation district. And that's what happened with all this mud flow and runoff. And so therefore they didn't have any problem finding that the department had jurisdiction to issue the violation. The other question was, did they have to pass rules to establish fines and damages because they didn't have such rules? And the Supreme Court said, no, agencies, you can adjudicate things prospectively by passing rules pursuant to Chapter 91, but in the case of damage like this, it's okay to do it through, basically retroactively through a case-by-case or ad hoc litigation process, which is what they did. So there had been testimony about the value of the reef and the damage done, and they could impose a fine based on that process rather than having to pass rules to govern it. Last one I want to mention is Kila Kila o Haleakala, which is a Hawaii Supreme Court decision, came out at the end of 2003. Again, a land board case. The land board was deciding a conservation district use permit for the telescope, UH's telescope over on Maui on Haleakala. There was a group of interveners or attempting interveners. Kila Kila o Haleakala was a group dedicated to protecting the sacredness of Haleakala and exercising cultural and aesthetic interests and all type of things. They petitioned for a contested case before the land board. The land board usually doesn't automatically do a contested case. It'll rule on things that come before it at a public hearing. They had neither granted nor denied the request for a contested case, and they took up the permit application and granted the permit application. And so the community group that hadn't been given a contested case appealed. And so the issue on appeal, it gets a little bit arcane, but most of the Hawaii cases have always said that there's a four-part test for when you get to appeal something and when you get this Chapter 91 appeal. And one of the requirements is that you participated in a contested case. Well, in this case, they didn't get a contested case. And at the end of the analysis, the Hawaii Supreme Court said you were, there was, in essence, a final decision because your request for a contested case was effectively denied, I think was their term, because they never ruled on it and they issued the permit. So you did what you could do. You have the right to appeal. You know, you tried to participate in a contested case. Doesn't matter that one didn't happen. So the land board has been kind of reversed in the Department of Land and Natural Resources a number of times on these denial of contested case hearing cases. There's the Kalaikini versus Thielen, which is a couple of years ago, dealing with burial plants down in Kaka'ako. And so I think, and I have a lot of cases that go through there, and sooner or later they'll probably get it right. But you know, I mean, they, for obvious reasons, don't want to do contested case hearings, but they keep getting things reversed. So that's the
okay. Let me blast through interest in real estate. There's a link to Lopez versus State, which is not a real estate lien case. It's a who wins in a child support enforcement agency lien versus an attorney's fee lien. And the state Supreme Court said the child support enforcement lien wins. So the takeaway is that liens are strictly creatures of statute. And that, you know, unfortunately for the attorneys in that case, they lost. But Malulani is an interesting case. It's unpublished by the ICA, but it's black letter law about implied easements with unity of ownership. And in that case, the question was, can the sovereign be the unified owner to satisfy that test? Now, normally, when you're dealing with patents or conveyances of land away from sovereigns, they are strictly construed in favor that there's nothing implied in what they give you, because the government reserves everything unless it specifically gives it to you. So this was a little interesting case when matched up with the Brandt versus United States case down below, which is a U.S. Supreme Court case. Anyway, so if you have a implied easement situation, Malulani is the current black letter law. John.
Let me just say one thing about Shorelines, Diamond versus Dobbin, and it's kind of the same lesson that one could say about anything related to water law, which is the Supreme Court always wins. Well, in the Diamond case, whenever it's shoreline, I mean, the lesson to shoreline owners would be it doesn't come out well. And so this is a shoreline certification case. You may recall the last Diamond case. The other lesson to this is don't live on Kauai and don't let Mrs. Diamond come anywhere near your property if you're trying to get permits. But so this is another Diamond case, Hawaii Supreme Court. And the lesson from the last Diamond case was, and for those who don't know, that shoreline certification is having the state certify or determine where on your coastal property the shoreline exists, usually for just 1 year. But it's necessary to get your building permits, it's necessary to determine where the shoreline setback area is, and all kind of other things. So it's an important determination. going back a long time, you had the Hawaii Supreme Court basically saying that it's a policy of the state to move that line as far inland as possible. And that's the Ashford and Sotomora cases. So you got to the point where we now have a statute based on Hawaii Supreme Court language that says these shorelines shall be located, and I'm going to paraphrase it and get it wrong probably, but at the highest highest point of the wash of the waves, as evidenced either by a vegetation line or a debris line. And so DLNR kind of looks at those two things as being indicia of what the shoreline is. In the first Diamond case, which is in 2006, the Supreme Court said to DLNR, you should always choose the more malca of those two pieces of evidence. So when you have a vegetation line, the vegetation line would be where plants stop growing because they're, subjected to storm or waves. The debris line shows how far those waves reach. And I think in the first Diamond, the DLNR had drawn it at one of those two lines, but there was a more malca line, the debris line. The court said you've got to follow that. Again, always moving that line as far inland as possible, meaning, and what that means is the public gets more beach at the expense of the property owner. So this Diamond case, the DLNR had been implementing what the Supreme Court told it to do for all these years, and the trick of all of it was the prior owner had gone in for shoreline certification in 2005. DLNR went out and said, okay, we see where that debris line is. It's kind of in the middle of the yard. They didn't go ahead and certify it and said they sold the property. New owner comes in 2008, goes through the same process again because you have to get shoreline certification. This time around in 2008, DLNR said, you know what, we don't see the debris line out in the middle of the yard where we did. We think, based on the evidence of where we see debris today and where we see the vegetation today, it's more toward the ocean. It's more Mackay now. And Mrs. Diamond and her friends challenged that and appealed that. So the Hawaii Supreme Court basically said, okay, you now need to consider historic evidence, and you need to discuss that, land board. So just because there's no evidence that for the past 2 years water had been washing as far back as it was many years ago, if come Aina testimony, i.e. these people who walk up and down the beach want to come in and say, I know what it was there before, they now have to consider that. So I mean, it just makes it even more difficult. I don't know where you draw the line to that, but it's another one of these Hawaii Supreme Court cases that's hard to implement. And I had a meeting with DLNR, and they're scratching their heads about how to apply this because they keep thinking they're doing it right, and then they keep getting slapped down. Shoreline certifications are going to be tough, and I mean, if you're that property owner, they're under a mandate to move it as far inland as possible, and now they've just got more ammunition to do that.
Okay, if you've driven up to the North Shore on the windward side and seen the sign that says eminent domain of use in Hauula, you know this case of James versus City and County of Honolulu, which is litigation going on in federal court where Mrs. James is trying to challenge the condemnation of her property for the Hauula fire station. All I gotta say is the City and County must want a fire station there bad because there's been a lot of publicity. They had that sign up there, and the sign got torn down, and there was a First Amendment challenge to tearing down the sign. Anyway, ultimately, I think there's going to be a fire station in Hauula, but that's the only condemnation case we had last year, and it's still going on.
So I don't think that condo fee case is worth talking about. Mitchell, it's just an example of an association bullying owners, which happens a lot. So do you want to talk about the national stuff?
The two cases I want to talk about, which are national, which are actually both coming from California. The first one, which is our second bullet point, is Property Reserve versus Superior Court. And that was a Court of Appeals decision. The link is for a Court of Appeals decision that found that pre-condemnation activities, so there's the condemnors have a right of entry, or they exercise a privilege of entry. I'm a landowner attorney. In order to survey so they can get the metes and bounds of what they're actually going to condemn. Most state statutes allow for that. HRS allows for it. It says the landowner has no cause of action against these types of activities. The California Appellate Court in that case said that's a taking. The right to exclude is one of your bundles of sticks. And if the city comes in and says, we get to come on your property and do our metes and bounds survey, they are taking away that right to exclude. And so the government in that case appealed to the California Supreme Court, the decision pens. I will note that HRS 101-8 or 18, there's an 8 in there, says that they can come in and do that. The last update to our eminent domain code was in the 50s, which predates. Yes.
Oh, okay.
Right.
Do you mind? I have this conference call for about half an hour, but then I'm in the main conference room, so could you do it in maybe half an hour and then you'll...
Right, you on mute? So it predates temporary takings jurisprudence, First English, Sierra, Tahoe, something. Sorry, Professor Callies. Anyway, the Supreme Court in the 80s said that temporary takes are compensable under the Fifth Amendment. And so I do think our legislature is going to have to look at updating our eminent domain code to account for that. The other one I wanted to mention is the City of Paris versus Stamper. And I should disclose that our partner Robert Thomas is doing amicus briefs in both of these cases in favor of the landowner. So with that, we might not be the most objective. But the Paris versus Stamper case, you know, in condemnation scenario, the landowner gets compensated at the highest and best use. And all states, including Hawaii, allow the landowner to provide testimony that upzoning or development potential is a factor of that, and have the valuation of their land being taken assessed at the highest and best use. So just because it's ag land now doesn't mean that the highest and best use is not urban, which is a much higher per square foot valuation. So in this City of Paris versus Stamper case, the landowner did that. But then the city came back and said, well, if you upzoned to a more intense classification, we would get a public facility dedication associated with that upzoning, and you wouldn't get... You wouldn't get, you'd have to give that to us for free. And so the value of what you're taking in your upzone scenario is zero. So your damages are zero. Then the landowner came back and said, wait. Nolan Dolan means that that exaction has to be tested, and that it has to be there has to be a nexus to my upzone, and it has to be roughly proportional to the impact of my upzone. So in this case, the question is, who does all this determination about highest and best use, Nolan Dolan, is it unconstitutional exaction, etc.? Is that judge or jury? And this California appellate court said that's a jury question. And so the city in that case took that to the California Supreme Court, and a decision hasn't come out yet, but definitely one to watch. Nolan Dolan exactions is a highly dynamic field right now in the wake of, well, it was before that, but the US Supreme Court last year in the Kuntz decision kind of breathed a lot of life into non-real property exactions associated with developmental permits. So expect some litigation in that department as well. Okay, we went over time. I'm sorry. If you have questions, Greg and I'll stick around after. We really appreciate the opportunity to come talk to your section. Sorry. We haven't, I'm on the HSBA board.